Law-abiding Minnesotan here with Minnesota Press, coming at you live from the Crow Wing County Judicial Center. Date is March 7th, 2025. Time is just before 12:25 p.m., about 12:23 p.m. right now. We just came from the post office to have served the plaintiff's response in opposition to defendant's motion for cost bond. The defendant in this case, case number 18CV242821, and you can go to mcro.gov in order to find information on that. Hey, Pinky, how's it going? The defendant and his slimeball attorney are doing everything they can to keep this out of appeals court. What happened was January 27th, 2025, a judge, I won't name the judge right now, made a decision, a judgment that was, how should I say it, had a chilling effect on First Amendment speech rights. And I filed an appeal, we filed an appeal February 27th, 2025. The defendant came back right away and motioned for a cost bond right away the next day, February 28th. And so here I am at the courthouse after just coming in from having served the plaintiff's response in opposition to defendant's motion for cost bond, as well as the declaration of the plaintiff in an affidavit to support that response. Furthermore, in a further effort to keep this out of appeals court, the defendant just this morning filed a proposed order to deny our OFP, or I'm sorry, our IFP application. What an IFP is a fee waiver. The appeals court requires a pretty hefty fee in order to file an appeal, and or you have to have a fee waiver. And the plaintiff had a fee waiver in the immediate court, in the lower court, used the same fee waiver to file the appeal, and somehow there seems to be a hang up with this fee waiver, with a hanging proposed order to deny the fee waiver, so that the judgment that was made on January 27th, 2025 in case number 18CV242821 will never make it in front of the appeals court. So that's their hope. Yeah, so that's what's going on. I just came to file the plaintiff's response in opposition to the defendant's motion for cost bond, as well as the plaintiff's declaration to support that response. And this is just interesting because this case is about First Amendment speech rights. And a sitting Minnesota House Representative, Joshua Heinzman, basically admitted to deleting comments and blocking people from his official Facebook page titled Representative Josh Heinzman. When that came to light and a pending 1A lawsuit, they found out a pending 1A lawsuit was coming, they deleted the entire page. And so all of the evidence, what evidence we don't already have in video and screenshot, that is, which is plenty, we can't get. And we planned on getting it through discovery. However, the defendant motioned to dismiss the first amended complaint and somehow won on January 27, 2025. That is the decision that I referred to as having a chilling effect on First Amendment speech rights. Again, that judgment is being appealed. The motion for appeal was filed February 27th, 2025, followed immediately thereafter on the 28th, a motion by the defendant to require a cost bond for the plaintiff to continue in appeals court, trying to keep that case out of court. I responded to it, and I had served my response, and I am about to file it now, as well as my declaration here on March 7th, 2025. Time is just about 12:30 now. You know, with the suppression of First Amendment speech rights going on here, and just ironic suppression. So first, the sitting House Representative Josh Heinzman suppresses speech by deleting comments off his public page and blocking people off of his official representative page. I mean, that's bad enough. That has enough of a chilling effect on the First Amendment. But then, when he's called out on it and a complaint is filed and the defendant motions to dismiss and the judge comes up with some reason why he shouldn't be held accountable for complying with the First Amendment, and then for the defendant to come back and try to keep the appeal away from out of the hands of the appellate court, this is just a deprivation of First Amendment speech rights of biblical proportions here. Furthermore, as I'm going in to file the plaintiff's response in opposition to the defendant's motion for cost bond and the plaintiff's declaration, I cannot document myself doing that. I'm gonna get as close as I can here. We're gonna go into this courthouse and try to file this declaration and this response in opposition to the motion for cost bond right now. Wish me luck. How's it going? Chad, are you gonna seize my phone if I put it here?
As long as it's not on record,
As long as it's not on record?
you can't leave it unattended on record, because if there's people coming and going and talking about legal affairs, you're recording somebody else's private conversation.
Yeah. As long as it's not on record, I can have it here?
Yep.
Like how would anyone know if it's on record?
They would know it's on record, but if somebody's talking about personal legal matters and you're recording that conversation, that's violating law.
Well, we're a one-party consent state, right?
You
Minnesota?
can't record somebody else's conversation without their knowledge of that.
Oh, one-party consent state.
So if an attorney and a client are walking out, you could be recording what they're talking about.
Why would they do that in a public area here?
I see clients and attorneys walking out talking all the time.
Well, that should be held for a private area, not a public one.
I'm just letting you know that if you record somebody else's pretty conversation and it's found out, you could be charged for that.
Okay.
It's called the scales incident.
Would you remind people not to have private conversations in public?
They can have conversations in public, they just can't have their conversations recorded. It's considered to be private conversation. You can't record other people's conversation in another part.
In public?
Yes. You're not supposed to even be recording in this building now. That's part of this whole court order.
I thought it was past the security.
You're within the Judicial Center right now. Right now you're recording.
But doesn't everybody sit their phones right there?
They set their phones there, but they don't record.
I'm just making sure you're not gonna seize my
I'm
phone
not
or
gonna touch
let,
your phone, Matt. We have cameras that watch this whole
Okay.
area.
or let anybody steal it.
We're not responsible for it. The safest bet is leave it in your vehicle. That's what we tell everyone.
Well, right, but if you sit here and see somebody steal it,
We're
then.
not here to watch your phone.
Well, right, but if you see them, if you see somebody steal my
If
phone,
you see somebody grab it, we will address it.
okay,
Yes.
cool. Sweet. All I got. Right now I'm lawful, right?
Okay, so then, and then do you have a belt on or anything?
I do.
Okay, go to that before we see, so then your pockets are empty?
Yeah.
Awesome.
We're all good as far as law is concerned so far, right, Chad?
Yep.
Okay.
Okay.
And just so you know, my intent is not to record anybody else's private.
Well, I never said that was your intent, Matt. That's just what can happen.
I just think it's pretty stupid to have private, especially sensitive, confidential conversations right out in public where anybody in the public can hear or see them. I mean, that's just stupid. You're that dumb that you're gonna have a private conversation with your attorney out in the middle of public. Well, that's not very right, you know, and that's not my fault.
Nope, I didn't say it was your fault, Matt.
It's stupid. I don't care if my stuff gets, my business gets, you can blast it. Turn on your body cam and stick it on YouTube and fire away.
We don't operate that way.
Well, I'm just saying, I don't have anything to hide, so. Set of keys and some court paperwork. I'll be right back,
Okay.
guys. Thank you.
Yep.
weekend.
Hi. Do you know where you're headed?
Social services,
So social services is across the street.
they used to be here, right? No?
I'm not sure, but I know it's more like.
What?
They've never been here.
Okay, so yeah.
Not social services.
Registration.
I just have some papers. I dealt with the people here for my dog's guardianship and stuff. Is that still
Do you
here?
have to
Yeah.
turn in like guardianship paperwork?
This is what I need to turn in.
Okay.
She's already got all the other
We can
stuff.
send you to administration to start, but it does say social services, which is a message. So, do you have any cell phones or anything on you?
I do.
So cell phones aren't allowed in the building.
Okay.
Safest place is going to be your vehicle, otherwise if you put on the whistle, we can.
Oh, I did leave it in the car because I had my Pandora on.
Do you have anything else in pockets at all?
Nope. All right.
Thanks, Chad. Have a good one, Crowley. Lubers. All right. Got her filed. I have a correction to make. I got a text while I was walking in there. That said, no, he didn't. And I wasn't sure what he meant. But I know what he meant now after I had this declaration and response in opposition to the motion for cost bond filed. Is he did not file a proposed order to deny my IFP. Correction, did not. The defendant did not file a proposed order to deny my IFP. He did not do that. The court filed that document themselves for the judge to complete after the hearing regarding the cost bond. If the defendant doesn't just withdraw his motion, which he should. Anyhow, if you guys want to stay up to date on this case, go to mcro.gov. mcro.gov, I believe, is the website. It's Minnesota Court Records Online. And look up case number 18CV242821. This is an epic battle for our 1A rights. If you care about your 1A rights, this is for you. If you care about your 1A speech rights, this is definitely for you. I'm going to cut it off there and get the heck out of hostile territory here. Until next time, this is law-abiding Minnesotan with Minnesota Press out.